Welcome back to the deep dive. Ready to get those brain cells firing?
Always.
Today, we're wading into the murky waters of AI and data privacy. And trust me, it gets deep quickly.
Well, absolutely. It's a real rabbit hole.
We're talking about the legalities of data scraping, focusing on everyone's favorite AI chatbot, ChatGPT. We've got a mountain of notes and legal analyses to unpack here, so where do we even start?
Well, imagine this. You're just casually browsing online, clicking links, maybe leaving a comment here and there. Normal, right?
Totally.
But here's the thing. All that seemingly innocent activity, it's leaving a trail of data. And that data, it could be ending up in the hands of AI developers, shaping the very intelligence of those systems. Your digital footprint, my friend, is a gold mine.
And most people have no clue it's even happening. So how do we protect ourselves? Enter the GDPR, the General Data Protection Regulation, the guardian of European data privacy. But how does this aging superhero hold up against the data-hungry behemoth that is AI?
That is the million-dollar question. See, the EDPB, the folks who interpret the GDPR, they've broken down how a chatbot like ChatGPT processes data. It's a multi-stage affair.
A data pipeline.
Exactly. First, you've got the initial data grab, often through this thing called web scraping.
Like a digital vacuum cleaner.
Pretty much. Then comes the cleaning and filtering, getting rid of the junk. And then the main course, training the AI on this massive data set. And finally, you have the AI spitting out responses based on all that training. Each stage has its own legal hoops to jump through.
And OpenAI, the brains behind ChatGPT, they've been leaning heavily on that legitimate interest argument to justify scooping up all that data. You know, we're making a super smart AI to benefit humanity. But how does that balance with our right to privacy? It seems a tad convenient.
Convenient and potentially very slippery. Luckily, we have the Riga Satiksma case to give us some guidance. This case laid out a three-part test for legitimate interest. It's not enough to just say, trust us, it's legit, they've got to prove it. First, is there actually a legitimate interest at play? Second, is collecting all this data truly necessary to achieve that interest? And third, does the company's interest outweigh your fundamental right to privacy?
So it's not a free pass. You can't just wave the legitimate interest flag and call it a day. You've got a great example in your notes about someone named Claudia ordering a pizza. Walk through how legitimate interest might actually work in that scenario.
Right. Okay, so Claudia orders a pizza through an app. A few days later, she gets a coupon in the mail for a discount on her next order from the same place. Now, this could be a perfectly acceptable use of legitimate interest.
How so?
Well, the pizza place has a clear interest in promoting its products and keeping customers happy. Sending Claudia a relevant coupon based on her purchase history, that could be seen as a reasonable use of her data.
Makes sense. Especially if Claudia has the option to opt out of those promotions if she wants. It feels very different from, say, a company tracking her every move online to bombard her with targeted ads.
You've hit the nail on the head. It's about proportionality. What if, instead of just tracking pizza orders, this company gathered data on everything Claudia did online? Her purchases, her location, her conversations, building a scarily accurate profile of her habits and preferences.
Yikes.
Right. Those personalized recommendations suddenly feel much more invasive, wouldn't you say? That legitimate interest argument starts to crumble pretty quickly.
Okay, we've covered the GDPR and this whole legitimate interest balancing act, but let's get real. What happens when companies get it wrong? You've got some juicy legal battles and DPA takedowns in your notes. Real stop you in your tracks stuff.
Oh, absolutely. It's like a courtroom drama, but for the tech world. And the fascinating thing is, these cases, even when they're not specifically about AI, they set precedents. They create these ripples that impact the whole digital landscape.
It's all connected.
Exactly. Take the Fashion ID case, for instance. Remember that one?
Vaguely. Refresh my memory.
So it involved a website using those Facebook like buttons. Pretty common, right?
Yeah, you see those everywhere.
Well, the court decided that Fashion ID, simply by having that Facebook plugin on their site, was partly responsible for the data Facebook collected through it.
Even though they weren't the ones actually collecting the data.
Exactly. It's that whole idea of shared responsibility. It means you can't just pass the buck when it comes to data. And this is huge for AI because it raises the question, when an AI tool scrapes data from a website, who's ultimately responsible?
Right, because it's not always clear who's actually doing the scraping or where that data is going. And it sounds like regulators are starting to flex their muscles on this, especially with AI.
Oh yeah, they're not messing around. The Italian DPA, for example, they hit OpenAI with a temporary ban. Can you believe that?
A temporary ban. Wow, they really brought the hammer down. What was their reasoning there?
Well, they cited a lack of transparency from OpenAI, like what data are you actually collecting and what are you doing with it? They also questioned whether OpenAI even had a legal basis for scooping up all that data in the first place.
It wasn't just a data grab then, they were breaking the rules.
Potentially, yeah. And here's the kicker. They were also worried about the risks to kids using ChatGPT.
That makes sense. Kids are particularly vulnerable online, and they might not fully grasp what it means to have their data collected and used by an AI.
Absolutely. And this all ties into a much larger debate about how far this legitimate interest argument can actually stretch.
Right, because if OpenAI can claim legitimate interest to justify collecting massive amounts of data, where does it end?
Precisely. And that brings us to those NOYB complaints against Meta and OpenAI. These complaints argue that using legitimate interest as a catch-all excuse for basically any kind of data processing goes against the core principles of the GDPR.
Which is all about protecting individual rights, not padding the pockets of tech giants. So, what happens if NOYB wins?
Things could get very interesting. We could see anything from Meta having to halt some of its data collection practices to a landmark ruling by the EDPB that sends ripples throughout the entire EU. This is a big deal.
So we've talked about the GDPR, the cases, and this whole legitimate interest gray area. But it seems like even within Europe, there's no real consensus on what legitimate interest actually means in practice, right?
Yeah, it's a bit of a moving target. You've got different countries interpreting it in their own way, creating this whole patchwork of regulation.
A patchwork with some patches a lot bigger than others.
Exactly. The Dutch DPA, for example, they're taking a hard-line stance. Like, hold on, legitimate interest doesn't give you a free pass to just do whatever you want with people's data. You can't just use it for any old commercial reason without getting explicit consent.
Which makes sense, right? It's putting the brakes on a runaway train. But then the European Commission steps in like, whoa, hold your horses, Netherlands.
Exactly. They sent that letter arguing that the Dutch approach was too restrictive, that it would stifle innovation and harm the digital economy.
So it's a classic case of finding that balance, protecting people's privacy without completely strangling businesses.
Right. And then, just to add another layer of complexity, you have that landmark CJEU ruling against Meta case, C25221. Remember that one?
Vaguely. Give me the gist.
Basically, the court told Meta that legitimate interest doesn't automatically give them the right to track and profile users for personalized ads just because they feel like it.
Because they can. Yeah, not a good enough reason.
Nope. That ruling was a huge deal. It sent a strong message. User rights come first. And genuine consent. It's not negotiable.
So where does that leave OpenAI? They've been relying on that legitimate interest argument quite a bit.
They have. And the privacy policy does mention using legitimate interest for things like security and service improvements. They even give users the option to opt out of having their data used for training those AI models, which is something, I guess.
It's a start, right? At least they're acknowledging that users should have some say in how their data is used.
True. But then you have Meta with this whole payer consent model.
Payer consent, what is that, like a digital ransom?
Basically. They're saying, sure, you can opt out of targeted ads if you pay us a premium.
Seriously. That feels so wrong. Like they're holding our data hostage.
It's definitely rubbed a lot of people the wrong way. Many experts argue that it goes against the spirit of the GDPR, which is all about freely given consent.
It feels like they're trying to find sneaky loopholes instead of genuinely respecting user privacy.
Right, like how can we exploit this, not how can we do this right?
And then you have Google, always trying to stay one step ahead. Their new AI, Gemini, takes a more, shall we say, multifaceted approach to data, contract performance for some things, legitimate interest for others, and they've even hinted that they might actually start asking for consent for some future features.
And imagine that, asking for permission, maybe they see the writing on the wall, like respecting user privacy is no longer optional, it's essential.
It really feels like we're at a turning point. The genie's out of the bottle with AI, but we need to figure out how to control it, how to make sure it doesn't run wild with our data.
It's not just about data protection, it's about shaping the kind of digital future we want to live in, one where AI is a tool for good, not a weapon for exploitation.
Well said. And that's something we all need to be thinking about, not just the tech giants and the regulators. So, to our listeners, I'll pose this question. What role do you want AI to play in your life? How much of your data are you willing to share, and on what terms? These are questions we all need to grapple with.
This deep dive, it was really just the tip of the iceberg. We barely scratched the surface of this incredibly complex issue.
But it's a conversation we need to keep having. So thank you for joining us on this deep dive into the fascinating and frankly unsettling world of AI and data privacy. We'll be back soon with another episode, ready to tackle the big questions and equip you with the knowledge you need to navigate our ever-evolving digital landscape. Until then, stay curious.